I think there's an urban legend out there, or myth, that prenups are not enforceable, that any lawyer can set them aside. Would you say that's accurate?
You know, I've heard the myth before, but it's not accurate. If a premarital agreement is drafted correctly, it is enforceable under California law. There's strong public policy for parties to agree in advance or before marriage as to how their property is going to be divided and how spouse support will be dealt with. So those agreements are highly favored under the law and will be enforced under the law, but they have to be done correctly.
Now that brings up a question. Do premarital agreements have to be, quote, fair? And how do the judges, courts view that issue?
You know, fairness is not an issue under a premarital agreement, you know, especially under property. They can order their affairs any which way they want. So the court's not going to get concerned about whether that's a fair agreement or not. The court's going to look at were the requirements met under the California Premarital Agreement Act, which is both parties having counsel, separate counsel, which gets expensive, but it's a requirement, that there's complete disclosure of all their finances before the marriage, and that they understood all of the facts and circumstances surrounding this transaction, and that they gave a knowing waiver of their rights. And you know, if those elements are met, at least on the property side of things, that's going to be enforceable. How do the courts deal with spousal support waivers in a prenup?
Well, spousal support waivers were not really recognized until about the year 2000. We had some legislation in the year 2002 that provided that you can limit or waive spousal support, but the court would look at whether that waiver or limitation was unconscionable or grossly unfair at the time of the divorce. So when we draft these limitations on spousal support, we have to advise the client that that agreement as to the limitation will be looked at and scrutinized by a court at the time of their divorce.
This is where it gets a little complicated. There's two basic parts to a premarital agreement. One deals with property, so meaning is the house, is the business, you know, their hard assets. Are these going to be community, meaning split in half, or is it going to be the sole property of either husband or wife? Those property provisions are highly enforceable, and they're just looking at, again, is it a voluntary agreement, both parties have counsel, etc., and those are going to be enforced. Spouse support's a little different. You can have a provision in the prenup that says there's going to be no spouse support at all at the end of a marriage, or that it'll be limited in duration, maybe half the length of the marriage or for 3 years, or maybe limited in amount, no more than X amount per month, or maybe no less than X amount per month. So you can have those limitations, but like Peter, you just mentioned, the court's going to look at those waivers or limits on spouse support at the time of divorce, because the marriage might last 20 years. And so you fast forward 20 years, you know, maybe one of the spouses is disabled. Maybe the other spouse has a lot more money than they expected they would have. Do we really expect the court to enforce a waiver of support when there's a disabled spouse? Even though at the time they made the agreement, they had equal control and power financially speaking, and it was totally appropriate to waive support, 20 years down the road after a long marriage, circumstances change, and we really can't foresee or predict whether a court would enforce that, because we don't want to see spouses get hurt.